You're not like a 17-year-old or 18-year-old. Ooh, what do I do?
No.
You knew that you had to report. So again, we're back to the question of why you're not reporting to probation. That's the easiest thing to do.
Corey Allen Sr. is back in court on a motion to revoke probation. After pleading guilty to drug possession, he now admits he stopped reporting, risking 3 years in prison.
Court is calling 2021 CR 60727, State of Texas versus Corey Allen Sr. Is it senior or senior?
Senior.
All right, is that like a senior because you're the second person with this name?
No.
Oh, just senior.
That's my last name.
All right, thank you. All right, could I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
Defense?
Ed Garza, Your Honor, for Mr. Senior. Senior.
Yeah, I just wanted to
I
say
want to
that.
pronounce it senior.
I get it all the time.
Yeah. So are you Corey Allen Sr.?
Yes, ma'am.
Are you the same Corey Allen Sr. who was placed on community supervision in 2021 CR 6027 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on February 9th, 2022 for a term of 3 years? Is that you?
That's me, Your Honor.
All right, state.
Yes, Judge. Violated condition number 4 in Bexar County, Texas. The defendant, Corey Allen Sr., did then and there fail to report to the supervision officer as directed for the months of March and April 2022 in violation of condition number 4.
How do you plead to that, true or not true?
True.
State.
We waive the remaining conditions, Judge.
Any objections to the state's waivers?
No, Your Honor.
All right, Mr. Senior, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 3 years in prison and up to $1,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there an agreement?
There is an agreement, Judge. We have an agreed recommendation. It's the same recommendation that probation is making. We'd ask that you deny the MTR, place Mr. Senior on GPS tracking for 90 days, biweekly drug test for 90 days on the, I guess it's the UA hotline, monthly drug testing thereafter.
Is that the agreement?
It is, Your Honor.
Why should I follow it?
I'm sorry.
Why should I follow this?
Well, Your Honor, my client admitted to me when I interviewed him that he lacked due diligence in doing what he should have been doing to report to probation. But
All right,
I
Mr.
told him he
Senior.
has to try harder.
Yeah,
That's all there is
Mr.
to it.
Senior, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand. Where have you been? Why did you not report?
My first report date was a couple months after I got released. I went down there, I did make an appearance, and they gave me a date, and I could never get Donna Coleman on the phone. And I could have been more proactive in pursuing
No,
that.
when they give you a date to appear, you appear.
Okay.
Every time I give people conditions, you know what I say? I say you can either report by Zoom or in person.
Yes, Your Honor.
So how old are you?
35.
You're not like a 17-year-old or 18-year-old. Ooh, what do I do?
No.
You knew that you had to report. So again, we're back to the question of why you're not reporting to probation. That's the easiest thing to do. Now, it may be time consuming. I've been a defense attorney. I've had clients come to me and say, I had to wait for 3 hours or 4 hours, but you're on probation. So it's like, do you want to wait 3 or 4 hours at probation, or do you want to go to prison?
Yes, Your Honor.
So we're back. Why were you not reporting? So you didn't report in March and you didn't report in April. And it seems to me you didn't report in March. You would have been doubly sure to report in April. So why are you not reporting on probation?
Your Honor, like my attorney said, I just should have been more proactive.
What were you doing instead of reporting? Were you using?
No, I was
And
working-
here's the thing, tell the truth, shame the devil.
I was working. I worked at Southern Warehousing. It's off of I-35 and 18 Center Parkway. And I don't have a good answer other than I should have been more proactive in reporting.
And I'm assuming you've done nothing on probation,
I have paid my first restitution.
but nothing else.
That's all I'm doing. Yes, Your Honor.
All right, and your restitution, how much was it?
$60.
And that was for drug testing, right?
No, that was just We had come to an agreement for $60 a month, and I got an email saying I owed $60 and I paid it.
I showed as a supervision fee.
Supervision fee.
All right, so probation, you all want him on GPS. How's that gonna solve his problem of not reporting? Is it just gonna be like when he doesn't report, we'll know where to pick him up?
Well, I would suggest the GPS monitoring and maybe weekly reporting for 60 days, just so that we could make sure that he is reporting, and then along with the officer's recommendation for the UA hotline, and then for, I think it said 90 days, and then monthly thereafter.
Okay.
Weekly reporting will get him in, the cycle of actually reporting and making sure he's on his, doing his tasks that he needs to.
Are you able to afford GPS?
Judge, I was gonna ask the court if you would please waive the fees.
All right. This is what the court is going to do. I'll follow your agreement as far as denying the motion, but what I'm going to do is, because I don't think there's a GPS that can be given to him with waiving fees. You're gonna do weekly reporting for 90 days.
Yes, Your Honor.
And you're gonna do the UA hotline for 90 days, and I want him to call in every day on the hotline.
Yes.
Yes, all right. And all of the conditions will remain. You better start doing parenting classes, you understand?
I've actually, may I speak?
Yes,
I've actually completed the CPS prior to this that we had discussed. And I do have proof of that. I don't know if that helps at all.
when was that done through CPS?
Like 6 months before this case.
No,
No?
that does not help at all. You know why?
That's fine.
Because you were given parenting classes with CPS, right? And you should have learned, and you said 6 months before this case, you should have learned that having in possession of a controlled substance is not a good thing to have when you have children.
Well, it was 6 months before the sentence. I picked up this case like 2 years ago.
Now,
Okay.
you need to do parenting,
Yes, Your Honor.
because that needs to teach you that when you sign a contract, this probation is a contract with the court, you have to follow through, because otherwise there are consequences. And those consequences could be you not seeing your child for 3 years, you understand?
Yes, Your Honor.
And I know that people have children come visit them at the jail and the prison, which I've never agreed with, but you don't want that to happen, right? So when are you reporting?
Every day, or calling every day,
Yes, and when are you reporting to probation?
once a week.
Yes, and I'm telling you right now, don't do this thing where I picked up the phone, I couldn't get in touch with my probation officer. You had better be at probation and have whoever's sitting at the front desk sign some documentation for you saying that you were there. You understand?
I do understand.
All right, is there anything else?
Nothing else, Your Honor.
All right, so you're gonna report weekly for 90 days, and you're gonna do the UA hotline for 90 days. And probation, if there's any misreporting or miss UA hotline, file a motion.
Yes, Your Honor.
All right, do you have any other questions?
No, Your Honor. Thank
You know what you're supposed to do?
Yes,
All right, good luck to you.
thank you so much.
You're
May I
welcome.
be excused, Your Honor?
Yes. Court is calling State of Texas versus Sky Daniels. Night mag number 6599176. Are you okay, Brenda?
Yes.
No problem. Can I have parties announced for the record for the state,
Marcus Sanders,
for the defense?
Albert Van Cleve.
All right, and are you Sky Daniels?
Yes, ma'am.
All right, you're here on a request for a PR bond. And it says that the court appointed counsel is Elizabeth Russell. Is she not?
She's one of my associates in my office.
All right, thank you. Mr. Daniels, do you have any objections to this attorney standing in for Ms. Russell? All right, defense, the court is in receipt of the application for PR bond. It's your request, you may proceed.
Your Honor, he's requesting a PR bond. He's not had any difficulties in the past. He feels he should be able to. bring a PR bond at this time.
All right, well, the court is looking at 3 pages of criminal history. It shows a conviction out of Las Vegas for battery, a conviction for controlled substance out of Sacramento, a conviction for theft, a conviction for destroying property of another out of Reno, a conviction for force. I don't know what ADW stands for, but this is out of Costa, Colorado. There is a conviction for criminal extortion threats. That's out of Denver. A conviction for disturbing the peace out of Denver. A conviction of failure to appear on assault out of Denver. A conviction of trespassing out of Denver. A conviction contempt disobey court out of Denver. Another conviction for disobeying a court out of Denver. A conviction for force with a firearm out of, I don't know where this is, but it's out of California, I'm assuming. Conviction of a fight or challenge to fight out of, I believe this is either California or Colorado. Violation of court order to prevention domestic violence. And then there is another contempt of court for disobeying court order. So it appears that he has more than this just from history. State,
Judge, you just went through our reasons why we would not have reached a PR bond. Not only the violent history, but also it appears that he has failed to comply with court orders as far as missing court dates and such. And then additionally, the charges of retaliation charge where he told the officer that he would take care of him when he sees him on the street. That's why we are not in agreement with PR bond.
all right, defense. All right, Mr. Daniels, I'm going to deny the motion. And is he, as a part of his conditions, is GPS ordered? If not, I'm going to request full GPS.
Judge, that was the other concern, was that the PR application says that he's homeless. And I know that in the past we had issues with individuals who were homeless and putting them on GPS, but
He needs to be on GPS. If there's some issue with GPS, then let the court know, and then we'll consider something else. But I'm going to ask that he be on GPS. Do I have a page on Sky Daniels? Mr. Daniels, I don't take any facts of, and I don't even want to call it any alleged facts. As far as what you're charged with, the retaliation, I don't take any of that as true because I haven't seen anything. So I'm basing this off of, the criminal history. You understand? All right, so that's going to be denied. And if you're released, I'm going to order full GPS. Defense, have you had a chance to confer with the state on the actual case?
No, Your Honor.
All right, if you would like to do that, of course, you're more than welcome to. We don't have pre-indictment settings, but if something is worked out and you want to put that on the docket, we can have that placed on the docket, even though it's pre-indicted.
Yes, Your Honor.
All right, thank you.
Thanks. That makes sense.
All right, your plea deadline date is going to be on July 21st. So on that date, you let the court know whether you're accepting or rejecting the offer. After that time period, if that offer is rejected, the court will not consider any plea bargain agreements unless it's open to the court. Do you understand?
Yes, Your Honor, may I speak?
Yes.
Me personally, I'm not taking no plea deal.
No, here's the thing. How old are you?
23.
All right, so this is what I was always told. We have 2 ears so that we can listen, 1 mouth so we can talk, but you have 1 mouth, not 2. So here's what I'm telling you. You can do whatever you want to. You can not accept an offer or not, but your plea deadline date is July 21st. After July 21st, I am not accepting any plea bargain agreements unless it's open to the court. So if you decide to go forward with a jury trial and that jury is in the hallway and they come in, you sit down, you see them, your attorney sees them, you do voir dire, and then you're like, curses. I want to do inter plea. I'm not accepting the plea. except one that's open to the court, which means you would plead open to the court and you would be subject to the full range of punishment, not whatever the state is offering. I don't want to know what the state is offering. Ethically, I'm not allowed to know what they're offering, but I'm giving you a chance because I don't require people to get a plea on today and then say, well, that's your plea deadline date, not considering anymore, because sometimes people need things to talk about. Sometimes people want to talk to their family. I don't know what your situation is, but your plea deadline date is July 21st. After that date, the court is not accepting any plea bargain agreements. State and defense, I'm going to want an acknowledgement of discovery on that date as well. Is there anything else for me to sign? All right, just get your reset form and then they will take them back.
Thank you, Judge.
Oh, it's good seeing you.
Thank you, Judge. Good to see you.
All right.
Thanks for the book, too, for the recommendation. Thank you.
Oh, hey, you're welcome. All right, the court is calling 2022 CR 4014, State of Texas versus Darren Kinsley Parker. Can I have parties announced for the record for the state, for the defense?
Oh, Wood.
And are you Mr. Parker?
Yes, ma'am.
All right, defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Judge.
All right, the court will find that the state is in compliance with discovery. Mr. Parker, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Parker, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with unlawfully carrying a weapon on licensed premises as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right for jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Parker, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargain agreement, there's a $1,000 fine to be probated. State recommends deferred adjudication, and this is to be run concurrent with County Court Cause number 661377. Did you understand that to be the plea bargain agreement? Defense, is that the plea bargain agreement?
Yes, Judge.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 120 hours community service restitution, no contact with All Star Gentlemen's Club at 9440 IH 10 West San Antonio, Benjamin David Covington, Bobby James Yanez, Joseph Ryan Pullen, MTR, and motion to destroy the weapon, which is a black Glock serial number ACSY328. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, before that, it might be a typo, but it should be the MRT course instead of MTR.
You know what, Brenda, do I have something wrong where I'm switching letters? No, it clearly states MRT.
Okay, I wrote MTR. So.
Okay, you know what? Well, we can pretend like you got it wrong and Brittany got it wrong. And it was right.
Yes, you're correct.
But yes, it's the MRT. See, you know what? I'm still gonna fight my ophthalmologist.
Yeah.
I'm not getting bifocals. I'm not gonna do it. Just not gonna do it.
And yes, Judge, state offer states exhibit 1 and all attachments.
Okay,
We've had opportunity to view it, no objections.
all right. And you notice that Bo didn't say anything, so Bo and I were right. His client was right. The rest of y'all were wrong. Mr. Park, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you apply for deferred adjudication. Is there anything you wish to say on behalf of your client?
Yes, Your Honor. First, we would waive a PSI to be sentenced today. He would like to address the court as well, but the main issue, Judge, for me, it's the 5 years. I'd like it to be 4 instead of 5. But his main concern has been the number of community service hours. He has a family and children, small children, 30 years of age. The main thing that occurred to my mind, he moved here from Virginia. He was not aware that that was a crime in Texas to carry a gun. There was no posting. I told him my memory in my 20s when I was going to such places, it was a bar was prominent about no weapons. A stripper club was not prominent about you couldn't, they didn't want to turn anybody away. So it's very hard to find a sign. So he understands, and we've talked about this, ignorance of the law is no defense. So he believes, and I advised him, this is the least painful. It's not pain-free, but it's the least painful way out of this mess within which he finds himself. So he's in agreement. He wants to comply. He's totally committed to complying. It's not a drug issue. It's not, I think the tap will reveal it's not an alcohol issue, but he did make a mistake and he wants to pay for that. He's 30 years of age. The 120 hours is going to cause a hardship. You've got small children and 2 jobs. So I think he would like to address the court with that in mind, Judge. And I talked to him about some courts will allow, if we could reduce it, maybe they didn't pay off some of those hours. But that's what, tell the judge. Actually, if you want to call him as a witness, I guess, Judge.
Sure, he can be called as a witness. He's already been sworn in by the
Okay.
clerk. So.
Go ahead.
I start work at I wake up at 5 to make sure I get work. I start work at 7 o'clock at Nemo's Bakery, and then I leave at 3 o'clock to go to my second job by 4. And I work at Earth Burger from 4 to close at 10. So I just don't see.
Is that 5 days a week?
That's 6 days a week. And then some of my jobs, I might work 6 days here and then 5 days here. And they work with my schedule.
How old are your children?
I got a 2 and a 4-year-old.
And do they live with you?
Not currently. Not currently, they don't. But
Were they living with you during this incident?
they were, but
With the mom?
yes. But me and the mom don't go together anymore.
I'm sure after this incident, because he's trying to figure out why you at the gentleman's club.
There was a big situation going on. That's my.
You know, some people go to gentlemen's club and everything. And what time did this incident occur?
It was around after the bar was closed, so around like 2 something.
You know what I always tell people? Nothing good happens after midnight. That's why you should be at home asleep. And then obviously you've never heard the song, It's Closing Time.
No, no.
All right, in that song, you know what they say? Last call for alcohol, finish your whiskey or beer. You don't have to go home, but you can't stay here. They told you, you can't stay here, and you didn't leave. If you would have just left, we wouldn't even be here. So now they're saying that they don't want you at any gentleman's, well, any all-star gentleman's club. So it's probably best for you not to go to any of those type of clubs. You understand?
Yes, sir.
You could have been at home drinking. And now when I place you on probation, guess what? You can't drink alcohol anywhere. You understand? So I saw, is there gonna be any marijuana issues with you?
Oh, no, no.
All right, so you're clean.
I don't know right now. I smoke off and on. Sometimes I be needing to smoke. I work a lot, so sometimes I do smoke, but I'm not like addicted.
I know sometimes people need to just do mellow.
Yeah, sometimes I just.
I eat cake to mellow out. I need to stop that. So you're gonna have to choose a new form of what you use to mellow out. Watch a movie. Sit outside, you know, listen to the birds. As my grandmother would always say, listen to the birds gossip. All right. How often are you seeing your children?
I talk to them every day, but seeing them, my it's our work schedule.
Okay.
Their mom also works.
So then who are taking care of the children?
They stay with their mom. And I also, you know, we're not together, but I'm still in their life full time. I always take care of them, spend money and stuff. We're just in different homes.
Okay. All right. This is what the court is gonna do. Oh, and before I do this, who was the other guy you were with?
It's about halfway through that police report. First
What?
name was T-I-S-H-A-N, T-Sean.
T-Sean Campbell. It's probably best that you don't hang around T-Sean because I could see he was a part of the issue. I don't know what they were saying when they were saying in here he was dancing in an antagonizing motion. I don't, what does that mean? Is it like break dancing where they're having a dance off or something? I don't know what that means. Does anybody know what antagonizing dancing is? Yeah, I'm just trying to figure. I saw that and I was trying to figure out what that was. So
Junior high, yeah.
yeah. So have you been around Mr. Campbell anymore?
I haven't been around anyone from that incident since that night.
So are you okay with me putting a no contact order for Mr. Campbell in this? Okay. So it's going to be $1,000 fine, probated. This is to run concurrent with 661377. 3 years deferred adjudication. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to ask for parenting classes. You can do that on your off days. And so once you complete parenting classes, the remaining of the community service hours will be waived. You understand? So there's to be no contact with, should I just say any dancing establishment? What is the proper way to say no strip clubs? Is there a politically correct way to say that? No clubs where women, I mean, where people are removing their clothing? All right, there should be no, you shouldn't be going to strip clubs. You understand? So I'm going to say no contact with strip clubs. And that includes all the strip clubs in Texas or wherever they may be. You understand? I think it's for the best. And Mr. Wood, if for any reason he wants to change that, I don't know, maybe somebody's having a party there or something, you can come to me and I'll listen to your argument. So there's to be no contact with strip clubs. No contact with Tishan Campbell. That's Tishan Campbell, Campbell. Benjamin Covington, Covington. Bobby, Bobby. Yanez, Yanez. Joseph Pullen, Pullin. Motion to destroy weapon. Black Glock. Serial number ACSY328. There should be regular reporting by Zoom or in person. When's the last time you used marijuana?
Over a month.
All right, we're gonna do regular UAs. All right, how long is the MRT class?
Let me check.
All right, thank you. We used to have a list of that. I don't know where it went.
Just give me one moment, I'm sorry.
Oh, no problem.
That's it.
We have one vendor that is about 12 weeks.
All right. Thank you. All right, proof of employment within 30 days. No employment as a home healthcare provider with minors. Do you understand? Okay. And so probation, I'm doing proof of employment within 30 days. No employment as a home healthcare provider with minors. All right, so the MRT program, here's the thing. How old are you?
29.
Sorry, what?
29.
29. Brenda, when I said I was 29, people said, no, you're not. You're probably just 30, just hanging on to 29 as long as you can. But I'm going to accept that you're 29. I'm going to, because your attorney is saying that you have the 2 children to take care of, plus you have 2 jobs. I know that there's not a lot of time to do a lot of things. And when I place people on probation, I want them to be successful. So I'm going to give you the moral recognition therapy course right now. Do what's right. You understand? When people ask you to leave a location, leave. You understand? Don't take what does not belong to you. You understand? Abide by the rules of the road. You understand? Be respectful to people. So even though your attorney is telling me that you didn't know you could not carry a gun at that location, and there may not have been signs everywhere, guess what? If you would have been respectful that night, you still wouldn't have been here. Because when they would have asked you to leave, you and your friend, instead of dancing antagonistically, would have just left. That's your class. Follow those rules. You understand?
Thank you.
Probation, is there anything else that he needs?
Do you want field visits at all?
Yes, we're gonna do field visits 1 time per month. All right, so what that means is probation is gonna be coming out to look around to make sure that everything is the way it should be. You understand? All right, you're whispering.
Oh, yes, ma'am.
All right, is there anything else that you need from the court in order to be successful?
Could I get a certificate of completion for that MRT? I like that.
Sure, I will give you a certificate of completion.
Very nice, Judge. Thank you.
You're welcome.
Thank you, Judge.
You're welcome. Mr. Parker, I'm going to show you what's entitled trial court certification. Mr. Wood, here you go. Trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. You have 2 children who are looking up to you. And children mimic everything they see. So be a good role model for them so they can say, hey, I'm proud. That's my dad. You understand?
Yes.
All right, good luck to you.
All right, thank you.
Thank
Sure.
you.
Just remain, take a seat in probation. We'll go over conditions with you.
In the Bexar County District Court, Judge Stephanie Boyd grants 3 years deferred adjudication, with strict terms, no strip clubs, drug testing, and parenting classes. 1 violation could mean up to 10 years in prison. For more real courtroom accountability and powerful judicial moments, like, share, and subscribe.
All right, and are you Mr. Lopez? Are you Mr. Lopez?
Oh, yes.
All right. And my understanding of Mr. Hernandez is that you've been appointed to represent Mr. Lopez today, is that correct?
It is correct, Your Honor.
All right, are you prepared to proceed?
We are prepared, Your Honor.
Mr. Lopez, I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes.
All right, are you saying Robert Christopher Lopez Jr. is placed on deferred adjudication in 2016 CR 9023 for the offense of assault, family choking, strangulation on May 1st, 2017 for a period of 5 years and extended for a total of 1 year? Is that you?
Yes.
All right, state.
Violated condition number 26, on or about the 8th day of June 2022 in Bear County, Texas. The defendant, Robert Christopher Lopez Jr., has been in there failed to comply with the rules, regulations, or instructions of the Bear County Community Supervision and Corrections Department duly diagnosed residential facility, and that the defendant has been unsuccessfully discharged from the program due to non-compliance with facility rules and medication management in violation condition number 26.
How do you plead to that? True or not true? Court will find violation of, sorry, did you understand by pleading true to violation of 26, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
All right, the court is finding violation of 26 true. Is there an agreement?
Yes, Your Honor. The agreement is to grant the state's motion and enter adjudication of guilt and assess punishment at 2 years confinement in the Texas Department of Criminal Justice and affirmative finding of family violence. The state is going to take into consideration a case JN number 1999693, which is an at-large assault bodily injury case. And it's just subject to the court's approval. It's a contemplation of the parties that the defendant get credit for his time in the Bear County Jail, as well as the time he completed in SATF and ISF, which would be a total of 941 days combined.
Did he successfully complete SATF?
He did not successfully complete SATF. He did successfully complete ISF.
All right, so defense, is there a reason I should give him credit for SATF if he didn't successfully complete it?
Your Honor, I believe that because he has been in incarceration and he has, at least in his opinion, tried to complete these matters, Your Honor, we would ask that he be given credit for all this time, since he has not been free to do anything else and has been paying his debt to society. In speaking to him, he was willing to agree to the offer because he wants to get on with his life.
All right, Mr. Lopez, if you had successfully completed SATF, then I would give you credit for that. But you haven't successfully completed that. So I will not give you credit for that. I will give you credit for ISF though. Okay.
Still has.
Okay.
Still has.
All right, so the court then is finding you guilty. I'm sorry, Mr. Lopez, are you waiving your right to appeal?
Yes.
All right, and are you asking me to follow the plea bargain agreement?
Yes.
All right. Then what the court will do, the court is finding you guilty. The court will sentence you to 2 years in the prison. There's an affirmative finding of family violence. Taking consideration JN number 1999693, give you credit for any time served and give you any credit for ISF. I didn't take this plea bargain agreement. Is there a no contact order or anything?
1 second, Judge. There was a no contact order. The individual's name was Erica, Erika, De Leon, DELCO.
All right, and there's been no contact with Erica De Leon. Do you understand?
Yes, sir.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
And also because this is an affirmative finding of family violence, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, sir.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you. We can go off the record. You're gonna have to do better. I understand when people have mental health issues, but you're gonna have to reach out and get help. Otherwise, you're gonna keep coming back to court and you're gonna look up one day and you're gonna find out that your minimum is 25 years. Do you understand?
Yes, sir.
All right, good luck to you. Thank you, Mr.
Thank you,
Hernandez.
Judge. Appreciate it.
Court is calling in probation. This is for deferred.
Yes, Your Honor.
Court is calling 2022 CR 4940, State of Texas versus John Robbins. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
Robert Mauer for defendant.
And are you Mr. Robbins?
Yes.
All right, Ryan, where are your crutches?
I'm just in the boot now, Judge.
Oh, okay, all right.
I'm
I'm,
upgraded.
I'm trying to help people follow doctor's advice.
That's not, yeah, I may not be doing that, but I have the boot now.
All right. Defense, I'm showing you the discovery acknowledgement. This is done. Have you received all the discovery in this case and did you review it with your client?
I have and I did.
Court will find that the state is in compliance with discovery. Mr. Robbins, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, I did.
Next, I'm showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
I believe so, Judge.
All right, let me find. Mr. Robbins, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did.
All right, you're charged with theft 2,500 to 30,000. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
You believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Robbins, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargaining page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargaining agreement, there's to be $1,000 fine probated. State recommends deferred adjudication. There's to be restitution of $6,118 payable in 2022 CR 4940 to Harbor Freight at 181 Southwest Military Drive. Did you understand that to be the plea bargaining agreement?
Yes.
State, is that the plea bargaining agreement?
It is, Judge.
Defense, is that the plea bargaining
It
agreement?
is, Judge. I wanted to address the court about community service hours that were recommended by the state whenever the court felt it was
All
appropriate.
right, let me ask you all, so I thought he had a second case. All right, next I'm going to show you what's entitled waiver appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargaining agreement. State is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 120 hours of community service restitution, and no contact with any Harbor Freight. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
It is guilty, Judge.
All right. State, any evidence?
Yes, Judge. State would offer State's Exhibit number 1.
No objections.
Mr. Robbins, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it to evidence, States Exhibits 1 and attachments, and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. How the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Well, that's the way PSI, Judge.
All right, anything you wish to say on behalf of the client?
Judge, I would just ask the court to probate as much of the community service hours as the court feels appropriate. John's brother is actually the co-defendant. His case has not been resolved. I don't know if he's going to have the ability to help out with restitution, but I did tell John if his brother doesn't pay, then he's going to be responsible for all of it. I've asked the court to take that into consideration when assessing his community service hours.
All right, so are you employed?
Yes.
What do you do?
I work for Dunkin' Donuts.
All right, what do you do?
I'm a manager, assistant manager at Dunkin' Donuts.
Do they understand what you've been charged with?
Oh, yeah.
And they're letting you handle money? Okay, so what's the best Dunkin' Donut? That's the most important question.
Probably Bavarian cream.
I'm a Shipley's man myself, too.
Okay. So do you have any children?
No, I don't.
All right. So do you live by yourself or you're living with someone?
I live with my family.
All right, and that family is?
My mother, my father, and my brother.
So I'm assuming you don't have to pay mortgage or anything of that nature.
Well, I pay them like a rent payment. So.
Okay. So what do you do in your free time?
Not too much. Just work a lot. I've been working like a lot.
Okay. All right, this is what the court is going to do. $1,000 fine, probated. 2 years deferred adjudication. Restitution of $6,118 to Harbor Freight at 181 Southwest Military Drive. 120 hours of community service restitution. court will waive 60 of those hours if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 60 of those hours will be waived. There's to be no contact with any harbor freight. There's to be regular reporting by Zoom or in person. Field visits, one time per month. Regular UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else that's needed?
No, Your Honor.
All right, Mr. Robbins, is there anything else you need from the court in order to be successful?
No.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes.
Counsel, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So I know you're an adult, but you're living at home with your parents. So what that means is your parents' rules go. So if they have a curfew time, that's your curfew time until you get your own place, okay? All right, good luck to you.
Thank you, Judge.
All right, the court is calling 2019 CR 3230 and 2018 CR 2419, State of Texas versus Michael Edward Cardenas. Can I have parties announced for the record for the state,
Michael Villarreal with the state.
for the defense?
Ed Piker from Mr. Cardenas.
And are you Michael Edward Cardenas?
Yes, ma'am.
And each of the cause numbers, I'm showing you what's entitled motion to enter adjudication of guilt, first amended motion to enter adjudication of guilt, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them? All right, and cause number 2019 CR 3230, are you the same Michael Edward Cardenas? Was placed on deferred adjudication of sexual assault child on June 7, 2019 for a period of 6 years. Is that you? And are you the same Michael Edward Cardenas who was placed on deferred adjudication in 2018 CR 2419 for the offense of evading arrest detention with a vehicle on June 7, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
State, are you proceeding on the same allegations in each of the motions?
Yes, Your Honor.
Defense, any objection to your client's answer be the answer for both motions?
No, I don't object. No objection to that.
All right, state.
Violated condition number 1, on or about the 31st day of January 2022 in Bear County, Texas, the defendant Michael Edward Cardenas committed the offense of assault in violation condition number 1.
Judge, we did not agree on which one it was going to be, but I said we weren't going to be true to that.
We'll just have it played out.
Pick another one.
We need to enter plea. So,
Okay. So how do you plead a violation of condition number 1? True or not true?
True.
Is it a true plea, counsel?
No, Judge.
Oh, he just played true.
Well,
Do you want him to plead not true to that
I
one?
want to plead not true to that. We can plead true to everything else.
That's fine.
All right, so state, are you withdrawing that being entered into the record, his plea of not true?
We have no objection.
All right, so state.
Violated condition number 5, in Bear County, Texas, defendant Michael Edward Cardenas, the defendant there failed to report to the supervision officer as directed for the month of February 2022 in violation condition number 5.
How do you plead to that? True or not true?
True. Say waiver may remain allegations.
Any objections to the state's waivers?
No, ma'am.
All right, did you understand by pleading true to violation of condition number 5 in 2018 CR 2419, court could find it true, grant the motion, sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5 in 2018 CR 2419? And did you understand by pleading true to violation of condition number 5 in 2019 CR 3230, the court could find it true, grant the motion, and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand? Knowing that you still wish to plead true to violation of condition number 5 in 2019 CR 3230. Then, and that cause number, the court will find violation of condition number 5 true. And as previously stated, the court is finding violation of condition number 5 in 2018 CR 2419 true. Is there an agreement?
There's an agreed recommendation, Your Honor, and that is to grant the state's motion in each cause, enter an adjudication in each cause, and assess punishment of 5 years confinement in the Texas Department of Criminal Justice Institutional Division. And then the state is going to take into consideration CM cause number 95488, which is the assault case that's currently pending unindicted that he previously put through to, but then withdrew.
Defense, is that the agreement?
Yes.
Mr. Cardenas, are you asking the court to follow that agreement? Sorry?
Yes, ma'am.
Are you waiving your right to appeal? I'm sorry?
Yes, ma'am.
All right, then in cause number 2018 CR 2419, the court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served, take in consideration CM 95488. And in cause number 2019 CR 3230, the court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2018 CR 2419. And there's chapter 62 registration. Just one moment. Is there anything else from either side with regards to sentencing?
Not from the defense.
All right, in each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those with your attorney? Did you understand them? And did you sign them? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction in each of these cause numbers, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record, Mr. Cardenas. Sometimes when people get sentenced, they think it is the end of the world because you have to do time. But you're still of an age where you can get out of prison and you can change your life. Do you understand?
Yes, ma'am.
All right, good luck to you.
The Bexar County District Court sentences Cardenas to 5 years in the Texas Department of Criminal Justice for each case, running concurrently. Despite the severity, he still has a chance to rebuild his life after release. For more courtroom outcomes and real justice in action, subscribe, like, and follow for updates.